Hello, this is Jackie Jones, and this is the third module of the lecture in week 2 of legal litigation and estate family law. And this lecture is all about the court appearance, and you're going to be doing that for your assessment task, briefing a barrister, and finalising a matter. How is that done? Are there different ways to do it? What are the pitfalls for considering either option? So, what happens when you go to court? Well, first of all, start back from the beginning. You filed an application, might be an initiating application, it might be, as in your assessment task, an application in a case because it's dealing with an interim matter. So you filed an application in a case and the affidavit in support of that application. If it is a financial matter, there would have been a financial statement being a pro forma document filed with the application and affidavit. When you go to the court and you file an application or you electronically e-file it, the matter is allocated a date, and that date is called the return date of that application. So that's the first time the application comes before the court, and there is usually a time period of say 4 to 6 weeks between the filing of an application and the return date of the application. Now that time period can be reduced if it's an urgent matter or if it's an ex parte matter, and you ask as part one of the orders you seek is short notice of the application, which means that you are asking the court to put you ahead of other matters that have been filed, and so you're seeking to bridge that gap, get an earlier date than what you would normally have been allocated. So you've got the date that's allocated, and in your matter, let's just work on the fact your court appearance is the 16th of January. And in real life, if you were going to court on the 16th of January, you would attend with your client with you. Now, it's very important when you do have a client attending with you that you tell the client what's going to happen, where they're going to sit, and in the family court, that is that they'll sit behind you when you are sitting at the bar table. Now, courts are intimidating places at the best of times. Particularly, you'll find if you start appearing in court, the first couple of times you go down, you'll be quite nervous. Even for your court appearance for your assessment task, I suspect you're going to be very nervous as well. And that's part and part of the process. I certainly was with my court appearance when I first started. And in fact, even when I had time off on maternity leave, when I had my son, when I went back to work and I had to go down to court, I thought, oh, what do I say? Just that period of time off can take away your confidence as to, wow, what do I say in this situation? Now, it's very important that when you do announce your appearance, you do so with a good voice projection so that the judicial officer can hear you. I don't mean to yell, but I just mean have a voice projection. It's important to spell your surname if it's appropriate, but you don't need to tell the court your first name. So I don't need to say, Your Honour, if I'm before a judge, Jackie Jones, because they're not interested in my first name. I don't spell Jones, but you may have a surname that might have a number of spellings, or alternatively, and this does happen, you might get into a routine of spelling your name, and that's just a process that you would start. So it might be Ms. Jones, Jones, Your Honour, I appear for the applicant wife. Always correctly refer to the judicial officer. If you are in doubt, ask the court officer who will be usually holding the court list in the Federal Circuit Court or the Family Court. And you'll just say, is this a judge or a registrar? What's important is that you know what the matter is about, and hopefully by doing the application and the affidavit, you'll have a good understanding of what this matter is about for your assessment task. Importantly, what do you want to happen that day when you go to court? It really is part of the preparation. It's not a matter that you go and wing it, and it's quite embarrassing for you, and it's a reflection of your professional identity if you don't know who you're acting for, whether you're the applicant or whether you're the respondent. Now, I'll give you a little bit of a tip as to where you sit at the bar table. For your assessment task, it's okay, you can sit in the middle. When you go to real court, in criminal matters, the prosecution or the Crown always sit at the side of the bar table that is closest to the jury box. Now, that will depend upon the layout of the courtroom, and courtrooms are always, well, are regularly different. So, in one court, the prosecution or the Crown might be at the left-hand end of the bar table because that's closest to the jury, but in another courtroom they might be on the right-hand side because that's closest to where the jury would sit if it was in a criminal matter. Now, in a civil matter, the applicant always sits on the left-hand side of the bar table. So if you are the applicant, you would go to the left-hand side, and that is an indication to the judicial officer that you are for the applicant. If you go to the right-hand side of the bar table and sit there, your opponent will be on the left-hand side. If you're on the right, that means that you are for the respondent. And it is the application that is before the court that determines where you sit at the bar table. So whilst you might be the applicant in the initiating application, you might be the respondent to an application in a case. Now, if it is the application in a case that is before the court, then if you are acting for the respondent, you would sit on the right-hand side of the bar table. Now, in the family court and the Federal Circuit Court, as I said, there's a court officer that is usually hanging around outside the court door, or they're just within the court room as you walk in. Now, if there is no one sitting at the bar table, go straight to the bar table. What normally happens in the family court and the Federal Circuit Court is that they will call the list, and a court officer might say, can I have someone sitting at the bar table if there is in fact no one sitting there? It is part of the court etiquette that that bar table always has somebody sitting at it unless there has been a person has been excused by the judicial officer. So, fairly seamless appearance, Your Honour. Mrs. Jones, I appear for the applicant wife in that matter. My client is present in court. The husband is represented by Mr. Brown of Brown Lawyers. I'm mentioning the matter on his behalf. By consent, I seek the following orders, and then detail the orders that you are seeking. Now, a couple of things. When you are mentioning the matter by consent, you are mentioning it for the solicitor. So it is, when it says I'm mentioning the matter on his behalf, it is on behalf of the solicitor, Mr. Brown of Brown Lawyers. It is not for the husband that you are mentioning the matter on behalf of. For your court assessment, be ready for questions from the bench. We will ask questions. It's not going to be of a legal nature in the sense of we're not requiring you to know cases or to give legal an opinion on something, but more to have an understanding of what your matter is about and what you're wanting to achieve. Now, once there has been a discussion between you and the bench, then the judicial officer will make orders by the court. Now, once the orders are made, after they've concluded, the appropriate way for you to respond is, may it please the court. Now, if you are the only one sitting there at the bar table in real life, you can say, might I be excused? And I have never seen a judicial officer say no. Some judicial officers say, don't wait, or please don't wait. That's the cue for you to be able to get up and leave the bar table. One thing that is very important is for you to have an understanding about what it is that the judicial officer is asking. So listen very carefully to the question and answer the questions. I would encourage all of you, if you have an opportunity, to go to a court. If you do have the ability to go to the family court or the federal circuit court sitting either in Sydney or in Parramatta, go there, spend half an hour, just watch and observe how a list proceeds. You'll undoubtedly see some very skilled and well-prepared advocates. You will also see some poorly prepared advocates, and really that's all up to you. A couple of tips I can say to you is that there will be a lectern on the bar table. Now that is a very useful tool for you to put your notes to assist you in your court appearance. But another tip, don't write sentences. The notes that you have should be in bullet points. They should be reference points. So I would never go to court with long sentences to read out, but rather bullet points that I can just glance down to and that I can have easy reference to if there is a question asked by the judicial officer. Have a look at what the court can do on your first return date. Are there certain matters that it can or can't do? Is there a practice direction that you need to be mindful of? Always be mindful that the court has jurisdiction to make the orders that you are seeking. So it's not uncommon for a court or judicial officer to say, where do I have the power to make that order? So if it is a fairly standard order, then that might not be an issue. But if it is one that has some degree of uniqueness, the court might ask where the authority or the jurisdiction exists for that. There are always ethical considerations. It doesn't mean that you ignore your obligations under the Australian Solicitors Rules, and I really do ask you to embrace that consideration. Have a think about what it means to do a matter by consent. That's actually what's going to happen in your assessment task. You are mentioning the matter for the other solicitor. So everything that you tell the judicial officer, because it is a mention by consent, has to be agreed. So you can't ask the court to make an order if the other side, for example, is unaware that you're going to be asking for that to occur, or it's something that you have not discussed with the other side and obtained their consent about, or if there is an issue between the two of you, as in between the two lawyers, for that to on a particular point. If there is an issue, then it may not be appropriate to do a matter by way of a mention by consent. It might be necessary, for example, if you have differing outcomes that you want to achieve, that you would say to the other side, look, we're not going to consent to that adjournment. If you want an adjournment, you'll have to engage someone else and come to court and ask for it, because we'll be asking for the application to proceed on that day. Now, that's not what's happening in your assessment task. In your assessment task, you've obtained instructions from your client, and your client has agreed to adjourn the application, albeit not terribly happy about it, but has agreed. So ultimately the matter might go to trial, and you might be asked by your supervising partner to brief a barrister or briefing counsel, and that just means engaging a barrister. Now look, many experienced family law practitioners, as well as practitioners in other jurisdictions, regularly appear as advocates in the court. In fact, accredited specialists in family law are supposed to be able to run interim applications as part of their expertise. So it's very common to see solicitors running hearings, just as I did in the family court and children's court and other matters where it was one that I had the appropriate skill and didn't require counsel to appear. But it might be that you do brief a barrister. Always be clear as to what you are briefing the barrister to do. Are you wanting it specific, such as the likelihood of obtaining orders, or to appear at a hearing, the trial, maybe an interim matter, to advise on a piece of evidence, or even to advise generally. Always think clearly about that, and that should be detailed in the brief. Who you brief, what my experience is that most young lawyers start briefing the barristers that the firm already is using. Now, that will continue for a while, but over time you will start developing a knowledge of barristers. You'll observe those who are prepared well, those who seem to be articulate in court, and who the court seems receptive when they are making submissions and presenting a case. It's certainly not a barrister who is nice to you and buys you lunch and coffee. What's more important, even that's very nice, but what's more important is that they are well prepared. They get paid a lot of money and well prepared for presenting your client's case before the court. When it's a complex matter or even on an appeal, you might even engage senior counsel. So then you've got to consider, well, what actually goes in the brief? And it's not everything from your file that goes in the brief. Observations is actually the summary of the matter, and you'll see the picture there on slide 9 that when I started in practice, we all used to tie up our briefs with pink ribbon. It still happens in some firms, but it's a tradition that seems to be eroding. I quite like it because it sort of, I don't know why, I just sort of quite like it. I like the pink ribbon. Chronologies are very helpful. As soon as I see a client, I start creating a chronology as a working, living document so that you can add to it and amend to it as required. But consider what is necessary for the barrister to know when you are sending the brief. Certainly, if there are searches from ASIC or land titles, the Land and Property Information Service, that if it's relating to a financial matter, they may be relevant, as would experts' reports. How do you finalise a matter then? So let's just assume, for example, that parties have reached an agreement prior to any proceedings being commenced. Well, we talked previously about dealing with that matter by way of an application for consent order. They can also be dealt with by financial agreements under the Family Law Act. But what about when matters are finalised during proceedings? So an application, initiating application has been filed, but between the filing date of that application and the hearing, or sometimes it's even during a hearing, the matter settles. And so solicitors would prepare consent orders. They are then filed with the court and the matter is finalised. Now, I mentioned that you can also enter into financial agreements. These can be done. My experience is that a financial agreement will be entered into for spouse maintenance if the matter settles during the proceedings, with the other matters such as financial, property distribution and parenting matters being by way of consent orders, and a spouse maintenance aspect, if it's relevant, being finalised by financial agreements. But there's a bit of a flashing light with financial agreements. I've just given a paper, or presented at a seminar for law cover on risks and traps in family law. Certainly one of the things that I talked about was financial agreements. They're fraught with danger. They are not documents that are an easy, simple, off the shelf, off the internet document that should be used. They need attention to detail. They need proper instructions. You are, in fact, asking the parties to enter into a contract to oust the jurisdiction of the family court to deal with their financial matters. I could spend a whole lecture talking about the risks and the challenges of financial agreements, and maybe some of you would like to go to the law cover seminars on the risks and pitfalls in family law, looking at financial agreements when they're advertised in the future. But certainly I would be just putting a red flag, making sure that you speak to an experienced family law practitioner before you start drafting any financial agreement. It is a source of new and bubbling work for law cover. It's not that you shouldn't do them, but but those who do them need to be experienced and have an understanding of the information required and the material that needs to be addressed for them to be binding. So it really is all about, that's slide 13 is a picture of the Family Court Federal Circuit Court at 99 Goulburn Street, Sydney. All in the preparation. And for your court appearance in your assessment task, listen to the questions, answer the questions, but importantly, know what your client is wanting to achieve, or you're wanting to achieve on behalf of your client, and know your matter. Family law is full of relationships that started out very happy, but they don't always have a happy ending. So that's the end of this module with week 2 lecture. Thank you.